All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores?
Present.
Senator Orenshaw? Senator Lang? Senator Nguyen? Senator Hansen? Senator Krasner? Senator Ellison? Chair Scheibel.
And I am here. Thank you. All right. We are getting started a little after 10 a.m. today. We are going to do a work session this morning. There may be another work session this afternoon. And I think that all of the items we're going to consider right now are reflected on the third revised agenda. So I will go ahead and open up the work session. We are going to start with AB 65. Mr. McDonald.
Thank you, Chair. Jared McDonald, Research Division. Assembly Bill 65 revises provisions related to guardianship. This was sponsored on behalf of the Nevada Supreme Court and heard on May 12th. The bill revises provisions governing guardianship proceedings for adults and minors. And among other provisions, it renames the State Guardianship Compliance Office as the State Guardianship Office and the State Guardianship Compliance Officer as the State Guardianship Officer. It authorizes the officer to hire accountants and investigators as needed and within legislative appropriations. And finally, it revises procedures for serving citations and petitions, authorizing courts to approve alternative service methods. There are no amendments for this bill. Thank you, Chair.
All right. Any questions on AB 65? Not seeing any, I would accept a motion to do pass.
So moved.
All right. We have a motion from Senator Orenshaw. We have a second from Senator Flores. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed say nay. All right. The motion passes unanimously with those present. And I will sign the floor statement to a volunteer named Senator Orenshaw. And that takes us to AB 167.
Assembly Bill 167 revises provisions related to the use of corrective room restriction. This was sponsored by Assemblymember Hansen and heard on May 6th. It requires a facility staff member to review the corrective room restriction status of a child detained in a state, local, or regional facility at least once every 24 hours. Any such review must include an assessment of whether a referral for a mental health screening, evaluation, or treatment is appropriate. And we did have one amendment submitted by Clark County. This was discussed during the hearing, and it would just substitute the words "an assessment" with "a review." Thank you, Chair.
Thank you, Mr. McDonald. Any questions on AB 167? Not seeing any. I would accept a motion to do pass AB 167. To amend and do pass AB 167. We have a motion from Senator Lang. We have a second from Senator Nguyen. Please mark Senator Nguyen present. And any discussion on the motion? All those in favor say aye. Aye. Any opposed, nay. All right, the motion carries unanimously to amend and do pass AB 167. I will give the floor statement to a volunteer named Senator Hansen. And that takes us to AB 193.
Assembly Bill 193 revises provisions related to certain victims of crime. This was sponsored by Assemblymember Koenig and others and heard on May 9th. It requires law enforcement agencies to furnish free, complete, and unaltered copies of all reports concerning a domestic violence incident upon written request of the victim. Law enforcement agencies must furnish these reports within 1 month of the request, regardless of whether the report is closed, and may redact personal identifying information as appropriate. And you have no amendments proposed for this bill. Thank you, Chair.
All right, any questions on AB 193? Not seeing any, I would accept a motion to do pass AB 193. We have a motion from Senator Lang. We have a second from Senator Nguyen. Any discussion on the motion?
Chair?
Please go ahead.
I'm going to vote to support it out of committee, but reserve my right. Thank you.
All right. All in favor say aye. Aye. Any opposed say nay. All right, the motion passes unanimously to do pass AB 193. I will sign the floor statement to a volunteer named Senator Krasner. And that takes us to AB 227.
AB 227 is behind the blue sheet in your binder. This bill revises provisions governing adoption. This was sponsored by Assemblymember Miller and heard on May 13th. It repeals, revises, and reenacts provisions governing the adoption of children, including agency adoptions, identified adoptions, closed family adoptions, confirmatory adoptions, and readoptions. We do have one amendment for this bill that was discussed during the hearing, and this was proposed by Kimberly Surratt. And among the many items that were discussed in the hearing, most of them were described as cleanup. A couple were described as substantive, and those include replacing video appearance with remote appearance, and reducing the number of days from 14 to 7 in which a child welfare service agency must submit to the court a report regarding the condition of the child and suitability of the home of the prospective adoptive parent or parents. Thank you, Chair.
All right, any questions on AB 227? Not seeing any, I would accept a motion to amend and do pass.
Second.
All right, we have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. All right, the motion carries unanimously to amend and do pass AB 227. I will give the floor statement to a volunteer named Senator Flores.
Thank you.
You're so welcome. And that takes us to AB 309.
Assembly Bill 309 revises provisions related to certain orders for protection against domestic violence. This was sponsored by Assembly members Hardy and Hibbets and others and heard on May 14th. It requires that certain temporary orders for protection against domestic violence served to an incarcerated adverse party include advice that the party must contest the application for an extended order by submitting a written response if the party is still in custody on the date of the hearing. And we have no amendments proposed for this bill. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on AB 309? All right, not seeing any, I would accept a motion to do pass. All right, we have a motion from Senator Wynn. We have a second from Senator Lang. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. The motion carries unanimously to do pass AB 309, and I will assign the floor statement to a volunteer named me. Oh, no, Senator Lang. All right, and that takes us to AB 351.
AB 351 is also behind a blue sheet there in your packet, and this bill revises provisions related to the jurisdiction of the Juvenile Justice Court over certain offenses. This was sponsored by the Assembly Committee on the Judiciary on behalf of the Joint Interim Standing Committee on the Judiciary, and it was heard May 13th. The bill grants juvenile courts limited jurisdiction to hear cases involving individuals 21 years of age or older who law enforcement did not identify for prosecution before they turned 21 years of age. If certain requirements are met and they are charged with a Cat A or Cat B felony committed when they are at least 16 years of age but less than 18 years of age, a Category A or B felony involving the use or threatened use of a deadly weapon committed when they were at least 14 years of age but less than 16 years of age, or a murder or attempted murder committed when they were at least 13 years of age. You do have one amendment proposed for this bill. This was discussed by Bridget Duffy during the hearing, and she proposes to amend the subsection 4 of section 1 to require the juvenile court to consider the delay between the alleged crime and arrest, as well as the impact of time on the reliability of witnesses and evidence when determining whether, based upon the interest of justice and public protection, to dismiss the charges or transfer the case to district court for criminal proceedings. Thank you, Chair.
Any questions on AB 351? Senator Ellison? All right, any other questions? Not seeing any, I would take a motion to amend and do pass.
Second.
I have a motion from Senator Wynn. I have a second from Senator Orenshaw. Any discussion on the motion? Not seeing any, all in favor say aye.
Aye.
Any opposed, nay. All right, the motion carries unanimously to amend and do pass. I will assign this floor statement to a volunteer who is me. And with that, we will move on to AB 384.
Assembly Bill 384 requires the chair of the Juvenile Justice Oversight Commission to solicit input regarding certain subjects related to juvenile justice. This was sponsored by Assemblymember Cole and heard on May 9th. It requires the chair of the Juvenile Justice Oversight Commission to solicit input from persons and organizations with knowledge and experience in wraparound services for children involved in the juvenile justice system, including those on probation or released from detention or treatment facilities. It also requires the chair of the Juvenile Justice Oversight Commission to submit a report to the commission and the legislature. You do not have any amendments proposed for this bill. Thank you, Chair.
All right. Any questions on AB 384? Not seeing any, I would accept a motion to do pass. We have a motion from Senator Orenshaw and a second from Senator Wynn. Any discussion on the motion? Not seeing any, all in favor say aye. Aye. Any opposed say nay. The motion carries unanimously to do pass AB 384, and I will give the floor statement to a volunteer named Senator Wynn. And that takes us to AB 520.
Assembly Bill 520 revises provisions related to adoption. This was sponsored by the Assembly Committee on Health and Human Services on behalf of the Interim Standing Committee on Health and Human Services and heard on May 12th. It codifies regulations that require the Division of Child and Family Services to investigate the background and personal history of every initial application for a license to operate a child placement agency, as well as every employee, volunteer, and independent contractor of an agency who may provide services to children, determine whether a person has a history of maltreating a child. You do have one amendment proposed for this bill. This was submitted after the hearing by Mrs. Williams, McDade Williams, with the DCFS. The amendment deletes certain sections, subsection 4 of 5, section 3, and sections 4, 5, and 11 pertaining to a process for obtaining background checks through the central repository. Thank you, Chair.
Any questions on AB 520? Not seeing any questions, I would accept a motion to amend and do pass. We have a motion from Senator Wynn. We have a second from Senator Lang. Any discussion on the motion? All right. All those in favor say aye. Aye. Any opposed, nay. All right. The motion carries unanimously to amend and do pass AB 520. And I will assign the floor statement to a volunteer named Senator Orenshaw. And that takes us to the end of our work session documents for now. We will be in a relatively brief recess. All right, we will be back in order. We have all of the members present the same members present as before we went to our recess, which is all of the members. And we are going to work through a few more of our bills to work session today. All of the work session documents have been provided to the members of the committee. I believe there are also copies available for the public at the door, on the table at the door, and I will open up the work session now on AB 3 and hand it over to Mr. McDonald.
Assembly Bill 3 revises provisions related to alternative dispute resolution. This was sponsored by the Nevada Supreme Court and heard on May 12th. This bill revises various provisions governing arbitration and civil actions, including increasing from $50,000 to $100,000 per plaintiff the monetary threshold for mandatory non-binding arbitration, revising provisions to accurately depict an arbitrator's fees as reflected in current arbitration rules established by the court, and authorizing short trial judges to award the prevailing party attorney's fees up to $15,000. And we do have 3 amendments proposed for this bill. As discussed in the hearing, the Nevada Justice Association proposes to amend the bill to revise the payment of fees and costs to an arbitrator. And then subsequent to the hearing, the NJA, the Nevada Resort Association, and Vegas Chamber submitted a second amendment proposing to delete Section 4 regarding the written findings of an arbitrator or panel of arbitrators. And then finally, the Chair Scheibel proposes to remove the provision sending arbitration awards over $50,000 to district court and under $50,000 to short trial. Thank you, Chair.
Thank you. Are there any questions on AB 3? Not seeing any, I would accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen. We have a second from Senator Orenshaw. Looks like we have some discussion on the motion, starting with Senator Hansen.
Thanks, Madam Chair. Now, I met with the court people, so I'm going to support it. Although I do want to get on the record that in the future, I would prefer, if we're going to have a bill from the Nevada Supreme Court, that it's actually exclusively from the Nevada Supreme Court. Maybe in the past that's happened, but in my years here, I think that's the first time I've ever seen a Supreme Court bill that actually had amendments from an outside private party. And so normally with a Supreme Court bill, it's kind of a slam dunk around here. So I just want to make sure that that reputation for the court is maintained going in the future, and that their bills are not used for other people to get things in through a process where they take advantage of the court's high reputation, because I think it could damage the court's reputation if that practice occurs. But yeah, I will support it as amended. Thank you, Madam Chair.
Thank you. Any further discussion? All right. All in favor say aye. Aye. Any opposed, nay? All right. The motion carries to amend and do pass, and the floor statement will go to Senator Krasner. That takes us to AB 88.
Assembly Bill 88 revises provisions related to juvenile justice. This was sponsored by the Assembly Committee on Judiciary on behalf of the Joint Interim Standing Committee on the Judiciary and heard on May 8th. This bill revises the requirements that a district attorney must give written approval and that a child alleged delinquent in need of supervision must make certain admissions before a juvenile court may dismiss a petition without prejudice and refer the child to a probation officer for informal supervision. And we do have one amendment proposed for this bill. This was discussed in the hearing by Angela Knott with the Washoe County Public Defender's Office. The amendment will revise Section 2 to specify when a juvenile court may dismiss a petition without prejudice. Thank you, Chair.
All right, and we also have an amendment to exclude Category A and violent felonies. Did you go over that?
I missed that.
Okay, there's also an amendment to do that. Any questions on the bill? Not seeing any, I will accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen. We have a second from Senator Orenshaw. Any discussion on the motion? Senator Krasner.
Thank you, Chair. I will vote yes to get it out of committee, but I want to reserve my right to change prior to floor. Thank you.
Understood, thank you. Seeing no other discussion, all in favor say aye. Aye. Any opposed, nay. We have one nay from Senator Ellison. And with that, the motion carries to amend and do pass. The floor statement will be given to a volunteer named Senator Nguyen. And that takes us to AB 192.
Assembly Bill 192 makes various changes related to real property. This was sponsored by Assemblymember Backus and heard on May 15th. It enacts the Uniform Easement Relocation Act and the Uniform Mortgage Modification Act, establishing procedures and standards for easement relocations and mortgage modifications. And you have no amendments proposed for this bill. Thank you, Chair.
Thank you. Any questions on AB 192? Not seeing any questions, I would accept a motion to do pass. All right, we have a motion from Senator Orenshaw. We have a second from Senator Lang. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed say nay. All right, the nays are Senators Ellison, Krasner, and Wynn. The motion carries to do pass Assembly Bill 192, and I will assign the floor statement to Senator Orenshaw. That takes us now to Assembly Bill 488.
Assembly Bill 488 revises provisions related to criminal convictions of certain crimes. This was sponsored by the Assembly Committee on the Judiciary and heard on May 13th. This bill expands the list of offenses under which victims of human trafficking may petition the court to vacate a judgment of conviction and seal all related records to include any crime under state law or local ordinances. The bill additionally revises the applicable criminal procedure, including requiring a statement from the petitioner certifying that they are a victim of human trafficking and prescribing the courses of action if a petitioner submits any official documentation in the support of the petition. And we did have an amendment outlined in the work session document, but that has been replaced, and that conceptual amendment has been provided to the members and has been placed on the back table in the committee room. Thank you, Chair.
Thank you. And to clarify, this might be more of a question for legal. With the replacement proposed conceptual amendment, this would allow the courts to retain some discretion to determine whether or not to seal records in these cases. Is that correct?
Yes, Chair. From my review of the revised proposed conceptual amendment, I believe it does that.
All right. Thank you so much. Any other questions on AB 488? Not seeing any, I will accept a motion to amend and do pass. All right, we have a motion from Senator Wynn. We have a second from Senator Orenshaw. Any discussion on the motion? Not seeing any, all in favor say aye. Aye. Any opposed, nay. All right, we have 2 nays from Senators Krasner and Ellison, but the motion carries, and I will assign the floor statement to Senator Lang. And that takes us to AB 489.
Assembly Bill 480, Jared McDonald for the record. Assembly Bill 489 revises provisions related to civil actions. This was sponsored by the Assembly Committee on the Judiciary and heard on May 8th. It revises provisions for civil actions involving wrongful death caused by homicide to allow heirs and personal representatives of a decedent to file a claim at any time upon a showing by a preponderance of the evidence that the death was caused by homicide. The amendatory provisions of the bill apply retroactively to any wrongful act or neglect causing a death by homicide, regardless of when it occurred, or any statute of limitations in effect at the time, including without limitation, any civil action that would have been barred by the statute of limitations that was in effect before the effective date of the bill. And we do have one amendment proposed for this bill. This is from the Nevada Resort Association, who proposes to amend the bill to authorize any action against a natural person or estate. This amendment also specifies that the civil action shall not apply to actions premised on any form of vicarious liability. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on AB 489? All right, not seeing any questions, I would accept a motion to amend and do pass. We have a motion from Senator Wynn. We have a second from Senator Lang. And any discussion on the motion? All right, all in favor say aye. Aye. And any opposed say nay. All right, we have one nay from Vice Chair Flores. The motion carries to amend and do pass AB 489. I will assign the floor statement to Senator Lang. Again, thank you for volunteering. And I believe that brings us to the end of our work sessions for this day. We'll go into one more very brief recess. We will remain in recess until the call of the chair. Thank you.